a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting joins you. He is a Melbourne solicitor. He is here to offer you some free, very general legal advice. Good morning, David.
Good morning, Raph.
Now, you actually had homework.
I did.
For?
Julia Baronia.
Now, we've got Julia.
Julia, yes.
Julia.
Yep.
I tell you, why don't you tell us what you discovered first, and then I think there's been a development. What did you discover?
I talked about, Julia lives in a 2-lot plan of Strata Subdivision, house at the front, house at the back. The house at the back is served by a driveway down one side. On the plan of subdivision, that's common property. Julia had 2 issues. The first one is that the person at the front would not contribute to the cost of the public liability policy that the owners' corporation is required by law to take out. And there was a dead or dying tree that needed to be removed before it became a problem for someone. I told Julia that there was a company that had an insurance policy that protected Julia in circumstances like that. I looked at the 3 major insurance companies and their PDSs over the last week. The answer is that if there ever was, there now isn't. You're on your own, okay? And I was going to recommend to Julia that it was an application that she would make to VCAT in the owners' corporation list. Look, we're looking at 18 months to 2 years. A lot can happen in that time. I didn't think of and should have thought of Dispute Resolution Victoria, which is, again, another state government body, but endeavours to resolve by conciliation rather than arbitration, rather than someone imposing a decision. It's an exploration of what might be done and how it might be done. So I would be suggesting first step would be Dispute Resolution Victoria.
Okay. Now, I don't know if there's been development or not. Julia, has anything changed?
Well, yes, since I spoke to you, I contacted the arborist, the council arborist, and he came out and had a look at the tree that we talked about, and it's dead. And he has advised that it be removed as soon as possible. It is a danger, and he's even going to bypass me needing to apply for a permit. Now, do I still need her? And he's going to provide me with a report of this.
So council approves it, but the question is what happens with the neighbour?
Do I still need her permission, seeing he's saying that the tree will fall? It's imminent that it will, and it is a danger.
David?
He's going to address the notice to the owners' corporation, which is the theoretical body created by statute that you and your neighbour at the front are members of. Now, that doesn't help you at all. If someone was to serve a notice on me, my view would be ask the neighbour to contribute but get the work done anyway. And then probably, if necessary, commence proceedings at VCAT for recovery of half of what you've paid for its removal, and probably are requesting an order that, as a member of the owners' corporation, she contribute to insurance.
Good luck, Julia. I'm glad the council came to your aid. I'm not sure it's a solution, but thank you. Peter is in St Kilda. What's your issue, Peter?
Oh, hi, David, Raph. I'm on the 6th floor of an apartment block in St Kilda, and the lift has been renewed and will be out of action for 12 weeks.
Wow.
I've lived here for over 20 years, and I want to continue living here. I don't mind using the stairs occasionally, but I think for 12 weeks, no. And my partner has a bad knee and struggles with the stairs.
Yes.
I'm just wondering what my obligation regarding rent is to the landlord.
Are you a government tenant, are you, Peter, or a private tenant?
Private.
You could endeavour... I don't like giving VCAT too much work, but you could dispute the rent for the period that the lift is out. I suppose my thoughts would be I'd rather have a planned renewal than it's broken and we don't know when we're going to get it fixed.
We've been through that over the last couple of years, believe me.
Yep. So I suppose if you were the 6th floor of a building without without a lift, you would expect your rent to be less.
Yes.
So you could go to VCAT and say, I want my rent reduced because I'm not getting the full benefit I have paid for.
Mm-hmm.
But you also need to remember that unless your landlord owns all of the building, the decision to repair and renew the lease is not simply your landlord's decision.
No, I realise that.
Yep.
Would it be best to... I have put it to my agent, and he hasn't come back as yet. Would it be best to negotiate a rent reduction?
That's where I would be going. I'd be saying, look, I don't have access. I need to make all of these other changes. A rent reduction, please.
Yep.
And if push comes to shove, you could go to VCAT, but the lift will be up and functioning, hopefully better than the old one before you have a hearing.
All right.
Yep.
Good luck.
All right. Thanks for your help.
What are the stairs like?
Stairs are fine.
Yeah, but it's
just too many of
It's a
them.
long way. Yes.
Yeah, I totally understand. At least they're there and at least they're functional. I don't know if that's really a
I
consolation.
think there have to be a fire requirement. There'd be a lift.
Doesn't mean
Be
they are.
stairs.
That's
No,
why I asked.
okay.
And like if they're not there, although probably you get more rapid action at VCAT about a stairs not being functional than a lift not being
No,
functional.
you'd probably get the council to close the building on the basis it wasn't fit for habitation.
Oh, would you?
Yes.
Oh, wow.
Yeah.
Let's hope no one's in that situation. Robin's in Ferntree Gully. What's your issue, Robin?
Good morning, David and Raph. I have an issue. It's with an old power of attorney
Yes.
that was made 30 years ago.
Yep.
Is it still valid?
Well, is the person who gave it still alive?
Yes.
Is the person it was given to still alive?
Yes.
Then it's still valid.
Okay.
Every time. So they've changed the law up 3 or 4 times since
Yes.
the power of attorney was granted.
Right.
Every change that they make grandfathers each document that was valid when the law change came in.
Right.
So we now have the Powers of Attorney Act 2015, which came into effect in 2016. And prior to that, the Powers of Attorney legislation was in the Instruments Act 1958. Every one of those changes grandfathers what was in place before.
Right.
Right. I once had a disagreement with Centrelink on the question as to whether you could use an old power of attorney. Right?
The new one.
Well, I then asked the power of attorney, I then asked the person at Centrelink every time they changed government, was she or she reappointed, or was it okay to keep going? That wasn't a hard argument, Robin. But so yes, it still works.
Excellent. Thank you very much.
Thank you.
No worries. Good luck, Robin. Robert is in Inverloch. It's about 13 minutes after 10. What's your query, Robert?
Oh, yes, good morning. Thanks for taking my call. First time and nervous caller.
Doubly welcome.
Thank you.
Because he's nervous? Yeah. Sorry, Robert. Keep going.
We purchased an established home at a coastal area about 12 months ago. I'm not going to mention the location or the council involved.
Then we won't remind anyone where you come from, Robert. Is that fair?
Thank you. And we didn't realise at the time, we just realised recently that the previous owner had, or should I say a previous owner, had an outdoor area constructed without a permit. So the construction was illegal. It was attached to the house and it was about 400 millimetres off the boundary instead of being either on the boundary or a metre set back from the boundary.
Yes.
And it requires appropriate fire rating to be complying, none of which was correctly done. The council don't seem to pursue, shall I call it, responsible parties in relation to this.
Well, I only have to have a go at you, Robert. You own it. You're the person responsible for it.
Yeah, so
why do I need to go at anybody else?
Well, we're taking all the appropriate actions now. It's a process that's undertaken and current now.
Yes.
I guess my query ultimately is, do I have a case for taking a civic action against, sorry, it's a civil action, isn't it, against the owner who was the owner at the time, who was obviously responsible for getting the builder involved.
Because you want to get your money back. Because you've got to fix it up. You want to know if you can take them to court.
I'm going to be out of pocket a fair bit of money to rectify all of this.
Yep.
And, we bought it and the Section 32 didn't highlight an issue. It just said no permits had been issued within the
Previous
past
7 years.
So it was,
yep.
Yeah. So
Do you have
it was
any
a matter
idea
of-
when the work was done, Robert?
Yes, about 7 to 8 years ago.
And do you know whether it was your owner or the owner before?
It certainly wasn't the previous owner, the people that we bought from.
Who may or may not have known.
Correct.
Yeah. As a general proposition, and what do you say the cost of the works was?
To rectify?
No, not to rectify. What do you think it cost to build 7 or 8 years ago?
Oh, I would just guess in the region of 20 to 30,000.
And you ought to be looking under the Building Act to see if you have an action against the person who did the building. Because there ought logically be a builder's guarantee for work that's less than 10 years old.
Right.
So it's been domestic building work on your property. 7 or 8 years ago, I think the figure was about $12,000, more than $12,000. I think it's now 16. There might be an action against the builder for building something that wasn't code compliant.
We've got little chance, I guess, of finding out who the builder was, but some chance of finding out who the previous owner was.
You can do a title search today and that will tell you who the previous owner was.
Yes, but how do I find out who the builder is?
You ask the person who owned it at the time.
Yeah. Yep.
I don't believe you have an action against that person.
But they condoned it.
Yeah, I understand. The proposition is that if you, I don't think you have an action anyway, but if you did, then you'd need to bring the claim within 7 years at the point when the non-compliance could have been reasonably identified.
Right.
And that's going to be more than 6 years ago.
So that's why you don't think he's got an action, because it's more than 7 years.
Well, we look at it from a trade practices point of view, deceptive and misleading conduct. I'm assuming that the person who was the owner before the person who sold to Robert wasn't doing this as part of a business activity, but rather was fixing up their holiday home or enhancing, in their mind, the functionality of the home. So the trade practices type consumer law-ish guarantees don't exist.
Right.
The question then is do I owe a responsibility to build in accordance with code? And the answer is probably not. I think the builder does, the plumber would, so you need to look and see who the trades were involved. Mind you, Robert, I've always felt a little bit uncomfortable by simply saying, well, tough. So I over the next couple of weeks, I'll have another look at it. But as a general proposition, Robert, it's probably not your vendor, and I don't think you have a claim against the vendor before.
Okay. Sorry, Robert.
Okay. It seems uncomfortable to have to accept that, but
well, I mean, one of the ways you could have done it was you could have got a building inspection report, and done all of that at the time you bought. Now, I know that's the trend in New South Wales, but it's not the common practice here in Victoria. The common practice here in Victoria is we rely on the vendor statement, but it is possible to get a building inspection report, which would have told you that the building didn't comply.
Good luck, Robert. Thank you for your query. I understand that's not much consolation. John is in Keysborough. What do you want to mention, John?
Yes, good morning, Raph and David. We bought a property at auction which was a subdivision, and there's a large section of concrete that goes from where the house is to the other across to the other property. The other property's only 4 foot away from the house, and the large section of concrete was done originally so that they could drive cars into we'll call it a double block. So what they've done is, rather than, and the section of concrete is sloped down, so it's got drains, and it's got a little drain and a couple of other pits. We'll call them pits. So there's drainage running through from one property to the property where the house is that I purchased.
Is there a strata subdivision? Is a subdivision with an owners corporation?
No. It's got its own title. The two properties, the two blocks now have their own titles.
Yes, but it's. I would have thought you wouldn't have got it past the builder, past the council, or the building inspector if your property drained through someone else's. The expectation is that you will each have a lawful point of discharge.
Well, the other property actually partially drains into the property that I bought.
Oh, it's around the other way. You're taking someone else's water discharge.
Yes, that's right. I'll be taking their water, yeah.
I'd be happy to talk to the building inspector at council.
Yes, I tried to, and they were on holidays, and there was no one there responsible to talk to. But the other property, the problem is that they said that they were supposed to get a drainage report, and the council let them off getting a drainage report by putting a requirement on title that when the building's built, that the matter will be dealt with then. So that's how they got the title transferred.
So is there a Section 173 agreement on your title requiring some work to be done?
When they build the property next door.
Oh, okay. So it's a land subdivision. There isn't yet a building next door. Yeah. So what will happen will be is when they do the building, at that point there will be a requirement that the other property be drained separately to you.
Yes, that's right. But the problem is they've got up to 2 years to do the building, and then apparently they can get another 2 years to do as an extension if they need to.
So what
4 years.
What are you trying to achieve, John? Given that you bought the property.
Yeah. And also they haven't put a fence in either.
Well, was there something in the contract that required to put the fence in?
I don't think so. No.
But what exactly are you trying to fix, or what do you want to get done?
Sorry?
What exactly do you want to get done, or what problem would you like to try and fix?
Want the fence up so you've got security, yeah.
Well, then you've either got a contractual term which says we'll put a fence in. I question in what part as to what the contract says between you and your vendor. Will they build a fence or won't they? And then the other one is if that doesn't work, then it's the Fences Act.
Yeah.
And in terms of the drainage issue, I presume the drainage issue was made clear at the time you signed the contract. Well, sorry, not made clear, but at least included in the contract.
John, I'm going to leave it there. Doesn't sound like it's going to be a simple one to fix. I'll get back to more calls in a moment.
Angela, weirdest date you've ever been on?
We've met online. He was like, do you want to head out for a walk? I was like, sure, why not? So I was sitting there waiting for him to arrive, and it turned up in the car next to me, just turned and looked at me dead can and stuck his middle finger up at me. I was like, right.
Breakfast. Was it a joke?
It seems to become a bit of a joke with friends now. We sort of will turn up and just stick our fingers up at each other before saying hello.
Breakfast with Sammy J on ABC Radio Melbourne.
This is ABC Radio Melbourne with Raph Epstein.
I can see from the text there's probably a good half-hour discussion in who you should get to check your land contract before one purchases it. Architect, building inspector, range of different experts that you might be called on.
Yeah, I think
That's okay.
I mean, I can tell you what the contract says.
Yeah.
But I can't tell you whether the building's any good.
No, well, that's the question. So who do you get to come and have a look at the thing? And
you spend millions, yes.
Well, yes, that's right. It might be more than half an hour. Mark is in Docklands, though, with an entirely different problem. Mark, what's your query?
So I was on a flight from Sydney to Melbourne. It was the second last flight of the day. They cancelled the flight, this airline. Said it was due to weather conditions, but all the other airlines sort of flew, albeit later, their flights. I had to get a hotel overnight. What are my chances of getting some sort of compensation for the hotel?
If you can prove that wasn't the reason why they cancelled the flight, okay. But in the event that they cancelled it for proper operational reasons, you've got nowhere to go. It's there. You might find that the airline's limitation of liability is the amount that you paid for your ticket. So, Mark, I'll give you a really silly example. Back when we used to have film, like that you took with cameras, there was a clause in the camera on the box that basically said your liability was limited to the cost of a replacement film.
Right.
Imagine, if you will, that you've gone and bought all of this film to photograph a wedding and none of the pictures come out. The film company's not going to want to pay to restage the wedding. So they limit their liability, and your limitation of liability is almost inevitably going to be the cost of your ticket.
What did the airline say, Mark, when you asked about hotel refund? Or, just paying for the hotel?
They were at first optimistic. Like, you call up after they're done and they're like, oh, yeah, we've got a process, submit a claim, which I did. And then it took them 17 days to decide, no, we're not going to pay it.
Right.
There is some money in the ticket, like it wasn't a rewards ticket or something, but it's not a lot. So maybe I'm stuck. Like,
yes,
VCAT fees are $70, so that's a fair chunk of the ticket price.
Okay, well, can't help you there, Mark.
Unless you get a whistleblower who can prove from inside the airline that the stated reason for the cancellation of the flight is wrong.
But it could be anything. I couldn't get a pilot to take the flight, so therefore I don't run the flight. Yeah.
Sorry, Mark. Jagwinder is calling from Cranbourne. What's your query?
Yeah, thanks for taking the call, guys.
Hello, Jagwinder. How can we help you?
Yeah, thanks, man. Look, I bought some furniture from a store, and it's about a month ago. I just want to cancel some of the items. It hasn't been delivered yet.
What does the contract say about delivery?
Yeah, they told me that it'll be in February.
Well, then you've got no basis to cancel. You can certainly endeavour to renegotiate, but at the moment the store that's providing the furniture for you isn't in default of the agreement. We're still in January. Yeah. They promised delivery in February. They're still okay.
Okay.
I'd be going into the store and having a discussion.
Yeah, okay, right.
Do you want a refund or a replacement?
No, I don't want to cancel all of it. I just wanted to cancel a few items. Just needed to free up with some money, something else come up, and that's the only,
Then I think they're best done face-to-face, Jagwinder. I would be going into the store and seeing to have a discussion and say, I can't afford everything I bought. Can we take that and that out?
Good luck, Jagwinder. Lisa's in Chelsea. What's yours, Lisa?
Oh, good morning. I'm just got a query. I'm an executor with two others, and the three of us are all beneficiaries. We've now looming up. We're in Victoria. We're coming up to distribution of funds.
Yes.
But one of us, myself, I want to wait the 6 months from date of probate.
Yep.
One sits on the fence and the other one wants his money now.
Yep.
So what's the consequences if the funds were distributed prior to 6 months of date of probate?
And somebody then makes a claim against the estate?
Yes, that's what I'm concerned about.
Answer would be you can't get the money back. Lisa, there is a provision, I think it's about Section 98 of the Administration and Probate Act, that, are there other people who might make a claim on the estate? Or is it just the three of you?
At the moment, there's only the three. We don't know of anybody.
I'm not talking about... my question is, are there eligible people who would be eligible to make a claim who have not yet stuck their hand up?
Not that we know of, no.
So there may be a child out there that no one shared with you. Is that what you're putting to me?
Well, potentially. I mean, I've heard of other stranger things.
All right, Lisa, there is if your claim is, your risk is limited to the pool of people, there's a provision in the Administration and Probate Act which essentially says I can go and get permission from the beneficiaries to make a distribution inside the 6 month period, and then they can't complain if the estate is diminished as a result of the distribution. So there is a provision in the Act that would enable you to make the distribution in a shorter time frame. It won't protect you if the child that no one ever told you about turns up, but it would prevent a claim by one of the others involved.
Okay, so if there's no others involved,
And if there's no others involved, and the three of you are the executors, the three of you agree with the payments, the prospect of one of the other two coming along and saying, I've now got enough, not enough, I'm making a claim against the estate, the chances of them getting up is nil.
Yeah, it's the same three. The three executors are the same three beneficiaries.
Then just go for your life,
Okay.
Lisa. Yeah,
Okay.
incredibly low risk.
Oh, okay. That's just what I wanted to hear.
Okay, write the checks today. Okay.
Okay,
Thanks,
you.
Lisa.
Thanks a
Thank
lot.
you.
Okay.
Thank you very much, Lisa. David Whiting, thank you very much.
Thank you, Raph.
David Whiting is here every Tuesday giving you free legal advice.